Hello, everyone. My name is Giovanni Nogales, and I am a paralegal here at Laos Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled Buying and Selling Home Health and Hospice Agencies. Today's presenters are Jennifer Papapanagiotou and Heidi Kocher. Jennifer Papapanagiotou focuses on compliance, regulatory, and transactional matters for a wide array of healthcare providers, including home health and hospice agencies. She has an extensive experience in analyzing proposed and existing business arrangements for compliance with federal and state fraud and abuse laws and drafting a wide variety of legal agreements. Ms. Papapanagiotou is knowledgeable in all aspects of state licensing for home health and hospice providers, and in Medicare and Medicaid enrollment, including initial enrollment, changes of ownership, and appeals of revocation actions. Finally, she assists clients with compliance plans, forming new businesses, and addressing Medicare and Medicaid program coverage and reimbursement issues. As for Ms. Heidi Kocher, is a partner with the law firm of Laos Parker. She has over 20 years of experience advising and defending healthcare clients on legal and regulatory matters affecting providers of all sizes. She is an expert in all aspects of compliance and privacy programs, including developing and deploying policies, procedures, and training. Her experience includes serving as a chief compliance officer and a chief privacy officer, implementing the various requirements and aspects of corporate integrity agreements, and responding to and defending audits from Medicare, Medicaid, and private insurers up through the LAG level. She received her JD from Georgetown University Law Center. She is licensed in Texas, Maryland, and admitted to the U.S. Court of Federal Claims. She is certified in healthcare compliance. Just a quick reminder, if you have any questions throughout the presentation, please feel free to type them in the chat box and we will address them as many as possible at the end of the presentation. So without further ado, I present to you your speakers, Jennifer Papapanagiotou and Heidi Kocher.
Thank you, Giovanni. This is Heidi Kocher. I'm going to start off and do the first half, and Jennifer will pick up and do the second half of our presentation today. Also wanted to toss out a little bit of a disclaimer. This webinar is for educational purposes only. And even though Jennifer and I are lawyers, we're not your lawyers. So if you have specific legal questions about a pending transaction, make sure to check with your attorney. And the other thing that I would say is these matters really involve a lot of very complex and detailed healthcare laws. Do make sure your attorney has experience in dealing with these healthcare laws. I recently had to do some work with somebody who was a general attorney, and with all due respect to the individual, he really didn't understand a lot of the nuances, and it took a lot of time and caused some issues in terms of education for him. Next slide, please. So we're going to have, do I have the okay, there we go. So this is some bullet points of what we're going to cover. We're going to talk a little bit about some trends, some transaction basics. We're going to briefly cover some of the relevant health care laws, look at important steps and documents in a transaction. We're going to address some post-closing issues, and then we have some special considerations for home health and hospice. Next slide, please. So in terms of trending, there is a lot of interest right now, particularly in Texas, in purchases of home health agencies. We are seeing a lot of private equity money coming in, and they are often backed by financial investors who may or may not have sensitivities to some of the issues involved in a healthcare transaction. We are also still seeing a lot of pandemic-related enforcement and audits, and actually those are really picking up. Remember that the public health emergency will end here in 8 days on May 11th. And we can really expect to see, again, a lot of enforcement and audits and lawsuits addressing sort of everything that happened during the pandemic. And as a result, the pandemic-related funding, the PPP loans, the provider relief loans, the SBA disaster loans, and so on, these are hot issues and need to be addressed in transactions as we go forward for the next, I don't know, year, 2, maybe 3 years. Another thing to note is that RAP suppression will be imposed on agencies with true CHOWs and a 100% share or member interest transfers if they were certified before January 1st, 2019. Again, this is part of...
Just to interrupt, I'm sorry. I think everybody's off RAP at this point. I need to update this slide.
Yes, that's true. That's true.
That's true. RAP suppression is an issue for anybody anymore. Sorry, that was an artifact from an earlier presentation.
No worry. That's also true with the move to value-based purchasing and so on. Yeah, we're seeing some of these things being changed. But again, there is still a lot of interest from CMS because they're also aware that we have a lot of private equity out there sloshing around, you know, looking for a place to go. And so CMS and the state agencies are very interested in what happens with a CHOW as well. Integrity auditors are still very active. I know Jennifer in particular is seeing a lot of suspensions and revocations along with overpayment demands. So that is something that you need to keep in the back of your mind because that can become quite an issue and can even scuttle a transaction. And that's the kind of thing that actually can pop up after a transaction. Last year I had a transaction where the sale closed, and about 6 weeks after the close of sale, one of the SIUs came back seeking an overpayment from an audit that had been done 3 years prior, and they'd never heard back from the audit, and everybody had assumed that the audit had basically gone away and everything was okay. And 6 weeks after the sale closed, there they were requesting money. So it caused a lot of scrambling by both the sellers and the purchasers to figure out who was liable for what. Next slide, please. All right, let's talk a little bit about some transaction basics. These transactions, particularly in the healthcare industry, can very much take months to complete, and you need to be prepared for the long haul. One of the things that we are also seeing here is if you have Texas state Medicaid contracts, the approval process to transfer those contracts or get a new contract is drawn out and lengthy. And again, that is a factor in these transactions. And because of sort of general increased complexities and costs as well as enforcement risks, what we're seeing again is many owners are choosing to sell their companies. They're getting good pricing for them. They're just tired of everything. And again, we have a lot of private equity money out there purchasing of home health and hospice agencies where they think they're going to get good returns. This is one of these transactions where you really should hire a lawyer. Healthcare, as we've noted, is subject to many, many laws and regulations. These are complex, detailed, and you will benefit from legal advice up front. Having solid legal advice up front actually will help, will prevent a transaction from running longer than it needs to. So make sure you do hire a lawyer in this. There are some things where you can, you know, do things on your own. This really is not one of those. Another thing you can do is consider retaining an accountant or a valuation expert to review and advise on the status of the assets or your entities. Many times the buyers will actually do this. They will bring in a valuation expert. And what they're looking at is most home health agencies and hospice agencies don't have a whole lot of hard assets, so they're going to be looking at your quality of earnings, your revenue, your accounts receivable. And there's often a lot of dispute about particular aspects of things like that. Next slide, please. So before you move ahead, you need to do your homework. You need to understand what your agency is worth, and you also need to know what is your point of no return and say, I'm done with this transaction, I'm not moving ahead, and you need to know what is your walk away point. And that's going to be different for everybody. We do see that many deals that reach the letter of intent stage never close, because at that point there is due diligence that happens, and some of the facts that come out in the due diligence process can change whether or not it makes sense for a buyer or a seller to move ahead with the transaction, and sometimes simply because the buyer and seller have a change of heart. You should know that every deal is in fact different, because every buyer and seller have a unique scenario. But generally speaking, they have similar or the same documents or processes. Most transactions are about 70 to 80% standardized, and the documents are transferable from industry to industry. And 20 to 30% are specialized to a particular industry. In healthcare, our transactions are a little bit more specialized given some of our regulatory concerns. And I actually have a transaction right now where the purchaser's attorney is not very familiar with healthcare, and the draft purchase document that he has brought forward pretty clearly indicates that there's some provisions in there that really just don't make a whole lot of sense. So we're working through that. Next slide, please. So this slide is basically a summarization of the important steps and documents in a transaction. The most critical to these are the letter of intent, or LOI. This is optional, but it is extremely common. What the LOI does is sets out the basic terms of the transaction, so things like purchase price, how you're going to pay it out, whether or not there is employment for the sellers afterwards. It is typically not binding, except for things like confidentiality and no-shop provisions while you're under an LOI. And the no-shop provisions mean that once you sign the LOI, you're not going to be looking to try to sell the agency to somebody else. The second step in the process is usually due diligence. Sometimes this flips a little bit. Sometimes some of the due diligence happens previously under an NDA, a non-disclosure agreement. But most of the time you have a letter of intent, and then you do, even if you've done due diligence previously, you do really thorough due diligence by the buyer at this point. So financial statements, all kinds of things. The amount of information to be turned over is sometimes surprising to sellers, but there's usually extensive due diligence. The third step is the purchase agreement and some ancillary documents. And the purchase agreement is actually your binding document. And what it is going to have is the purchase price and terms, including any holdback and escrows and any earn-out provisions. It will have what are called representations and warranties, or as we attorneys abbreviate it, reps and warranties. And these are promises that you make to each other, things like you don't owe back taxes, nobody's been excluded, etc. There will be indemnifications, such as what happens if the government comes back and says, oh, we've audited you and we think you owe X amount of dollars. There are going to be exceptions and limitations to indemnifications, and then ancillary closing documents. And these might include, for example, employment agreements for the sellers if the sellers choose to become employed by the purchasers. After you have negotiated the purchase agreement and you've met any conditions to closing, which is also something that's going to be in the purchase agreement, you will actually go to closing. And closing can be in person. It's not so frequently in person anymore, but basically you exchange signed documents, and then of course money is sent from the purchasers to the sellers. If there's an escrow, the escrow agreement is funded, and so on. Next slide, please. We have said this before, but before you draft and sign an LOI or a purchase agreement, really do discuss the transaction with an attorney who is experienced in healthcare transactions. Again, there are pitfalls in here that are not necessarily widely known to sort of general transaction attorneys, And certainly if somebody brings in an attorney who is just, wills and trusts or divorce lawyer or something like that, you're going to get yourself into, potentially get yourself into a lot of issues, and certainly it's going to make the deal much harder to arrive at all the terms in a purchase agreement and then close if the attorney is not familiar with all the requirements. Also be aware that federal and sometimes state laws can impact the terms and timing of a healthcare transaction. For example, licensure issues. In Texas, we have to notify HHSC ahead of time if you're going to be changing licensure issues. So those are going to be factors that may impact the timing. And the attorney will help outline limitations in purchase price, financing, notice periods, and other terms. Again, we have to be aware of some of the other laws. So for example, if a buyer will pay a seller over time, the healthcare fraud and abuse laws may limit how long that period can be, and also possibly the structuring of how your payout is. Next slide. All right, we're going to go ahead and just, again, briefly summarize some of the relevant laws that are going to be affecting a transaction. So, of course, the first one is the Stark Law. And you all knew this was coming, Stark and anti-kickback, right? So, as a summary, the Stark Law prohibits a physician from referring patients for designated health services to an entity in which the physician or his or her immediate family members have a financial relationship unless an exception applies. Home health services are designated health services, DHS, so Stark does apply. So Stark applies, for example, if the seller is physician-owned and might ever refer any Medicare patients to the HHA, the home health or the home health agency, after the transaction, so to the buyer. Remember that the Stark Law is a strict liability and a civil statute, so you can't go to jail for violating the Stark Law, but a violation does result in the obligation to refund all payments that are improperly received or tainted by the violation, and possible fines. So an example where this might be is the home health owner sells a home health agency, but still owns a hospice or another healthcare business that may generate referrals to the home health agency. So again, you want to be very concerned and very cautious to make sure you know who your buyers are and you know who the sellers are. You don't want to run afoul of the Stark Law. Next slide, please. There is an exception under the Stark Law for what are called isolated transactions, and this has a number of requirements. The first is that the total payment must be fixed in advance, or if you're doing this pursuant to a formula, the formula must be defined in advance. So you can't vary the formula during the transaction. A key requirement is that the price must not take into account the volume or value of referrals. That's always our big no-no there. The transaction has to be commercially reasonable, even if there are no referrals to the buyer from the former sellers. And there must be no other transactions between the parties for 6 months except those that meet another exception. So your sellers could take on an employment arrangement agreement that would fit into an exception. Medical director will fit into an exception for personal services and contracts, and there is also a group practice in-office ancillary services exceptions. So again, you can see why these are complex and why you want to make sure that the attorneys really know what they're doing on this. Next slide, please. We also have the anti-kickback statute to be worried about. And just to summarize, the anti-kickback statute prohibits the knowing and willful exchange of anything of value, called remuneration, to induce or arrange for referral payable by Medicare, Medicaid, or any other federally funded healthcare program. the anti-kickback statute is, in fact, a criminal statute, and violations can carry significant penalties and even jail time. One thing about this is the government, again, must prove the knowing exchange of anything of value. So the government does have to prove some level of intent, which is different from the Stark law, which is just black and white. Either you did or you didn't. Doesn't matter whether you intended it or not. Transactions that are among parties who refer to each other are subject to the anti-kickback statute. And again, there are a number of safe harbors under the anti-kickback statute where a transaction may fit. Next slide, please. So for example, there is the sale of a practice safe harbor. And this protects transactions among practitioners. There we go. And between practitioners and hospitals if you comply with every element and requirement of the safe harbor. Now, this technically is not applicable to home health and hospice transactions, but what often happens is the government will use these as a yardstick to measure whether or not a home health / hospice transaction is in fact acceptable. And so you want to be able to look at that and determine if you could meet the requirements of that. This safe harbor actually places time limits on completing a transaction and on referrals after closing between the buyer and the seller. One thing to note with these safe harbors is that if you do not meet all the elements of a safe harbor, it is not illegal. The transaction is not illegal. The government then has to, again, look at all of the facts and circumstances to prove intent, as I mentioned earlier. Next slide, please. So if a transaction doesn't fit into a safe harbor, what can you do? Well, some of the things that you can do is you can ask your lawyer for an advice letter that outlines the transactions, analyzes the risks, and documents the steps you have taken to mitigate those risks. And you keep those among your records involving with the sale. And this is a little bit of the defense of counsel. And again, this is why we say you want to make sure you have experienced counsel with this, because these are the kinds of things that are looked at, and we can make sure that we've addressed all the potential pitfalls. Another thing that you can do is you can retain an appraiser or a fair market value expert to determine the fair market value of the agency being sold. This is really the best proof that you can develop that a transaction represents fair market value and is commercially reasonable. Yes, it is a little bit expensive sometimes to retain an appraiser, but I think you need to think of it as an insurance policy, particularly if you have significant sums in the transaction. And again, that's one of the factors that the government looks at. Is this fair market value, and is it commercially reasonable? And having the independent third-party documentation from an independent appraiser is quite important proof for that. Next slide, please. As we said, there are some important steps in documents. I'm going to talk here a little bit briefly about a letter of intent. Again, this is optional. Some people actually manage to negotiate the terms of a purchase agreement without a letter of intent, but it is very common, and again, it helps to sort of put boundaries around the transaction, say what the transaction is going to look like. Many times, purchasers will want to sign a letter of intent because, as I mentioned earlier, it also has provisions in it of confidentiality and preventing the sellers from shopping the agency to multiple potential purchasers during this time. So there's some exclusivity provisions in a letter of intent that purchasers often want to agree on. So again, this is a preliminary document. It lays out the key terms and opens negotiation. And it really does set the tone for the coming transaction and negotiations. So you want to make sure that it is well crafted and has the appropriate elements in it. And again, if a purchaser presents you with an LOI, be sure to seek legal advice before you sign it. Again, these are some of the things that you really don't want to do on your own. Next slide, please. The next step is due diligence, and the principle that applies here is what is known as caveat emptor, or Latin for buyer beware. Both parties will conduct some due diligence, but most of the time it's mostly the buyers, and they want to ensure that the business or ownership interests that they are purchasing are what they think they are. Sellers may do some due diligence as well, just to make sure that the sellers, for example, if they're going to offer a note or a promissory note to finance part of the purchase price, you want to make sure that they're going to be able to, make the payments under the note. So some of the documents that you're going to be requested to turn over in the due diligence process to the purchaser will include financial statements, tax returns. They're going to look at business operations, assets and liabilities, office locations, licenses, certifications, personnel matters, right? Particularly if they're taking on all the employees, and all of the other aspects of the business. It is also not uncommon for them to do claims audits, where they will take a look at your claims records and will audit the underlying documentation to make sure that the payments you're receiving for services are correct and that they won't be subject to some sort of repayment obligation afterwards. Next slide. Again, so because of these issues, you should do a mini claims audit as well. If the buyer takes on the provider numbers, they get all of the seller's Medicare and Medicaid successor liability. So the buyer is definitely going to want to do a claims audit. Even if they don't take on Medicare and Medicaid numbers, they will typically do a claims audit. But you should do a mini claim audit beforehand to make sure you understand what your documentation looks like and to be able to address any deficiencies if that's what the claims audit presents. And you can start fixing those issues beforehand. Don't be afraid to engage an expert if necessary. And again, what you want to do is identify weaknesses in the medical records and other documents supporting claims, the face-to-face visits and so on. Big problems either will greatly reduce the purchase price. They may lead the buyer to seek a large post-closing escrow to protect against the possibility of a claims audit, or it may kill the deal altogether. Next slide. Jennifer, you want to take over?
I would love to. Happy May 3rd, everybody. So we're going to move into talking about once you've gotten through the initial stages of a deal, negotiated your terms, perhaps you've signed a letter of intent. And I would say in most of the deals I work on, we do letters of intent. You move on from that point past due diligence, making sure the buyers are comfortable moving forward. And then you draft, usually the buyer's counsel drafts a purchase agreement. And this is the basic and most important definitive agreement for any transaction. It's going to set out all the terms of the deal, including price. It's going to talk about risk allocation. It's going to talk about all of the material provisions of a transaction that protect both the buyer and the seller and whatever terms you've negotiated. So it's going to talk about closing and payment and penalties and liability exposure, indemnification, all of those important elements when a seller sells a business to a buyer and you agree how things are going to work both for purposes of the transaction and after the transaction. So it's really, really important that this definitive purchase agreement accurately reflects the parties' intentions regarding the sale of the business. It's not uncommon for purchase agreements to get drafted, that first draft that comes from a buyer's attorney to a seller's attorney. And it might include some gaps or some things that the parties hadn't fully discussed when they originally negotiated, things that you don't put every term into a letter of intent. And it's really important that sellers and their counsel carefully review this document make sure it captures the terms that have been agreed to, that you resolve any questions or uncertainty regarding any of the terms, that you understand the terms, and that you understand the representations and warranties that are being made by the seller to the buyer. Those are a key source of potential issues after you close a transaction. So it's very, very important that those are accurate and that any disclosures that need to get made are made. Let's go to the next slide. So there's 3 different types of transactions that you can enter into. There's an asset sale, an equity sale, and we almost never see it, but large companies sometimes execute mergers. In an asset sale, a buyer is buying certain things owned by the seller entity. They're not buying the seller entity itself, they're just buying the things that seller entity owns. And it generally, the way you can tell it's an asset sale, the simplest way is that after the transaction is done, there's a brand new owner of all those assets with a new tax ID number after closing. In an equity sale, the buyer is buying the seller's equity interest. So if you have 2 shareholders in a corporation, the buyer is buying those shareholders' shares in the corporation that is the operating home health or hospice agency. After the transaction, the business itself has the same owner and the same tax ID number, but it has different shareholders. So those are the 2 most common forms of transaction we see in home health and hospice. Let's go to the next slide. So we do see some unique issues, and this is one of the reasons why we recommend that when you do retain counsel, whether you're a seller or a buyer, that you have someone who's familiar with healthcare and understand some of the unique issues. In an asset sale, home health and hospice agencies don't have a lot of hard assets. They don't own a lot of things. It's not always the case, but you don't own big facilities. You don't own a lot of medical equipment, generally speaking. Most of the value of the business is in goodwill. And in asset sales, in most all transactions, the buyers generally do want to take assignment, what we call assignment of the Medicare and Medicaid provider agreement and billing numbers, but they don't want any other liabilities. They don't want to take on your tax liabilities. They don't want to take on money you owe to a bank. So asset sales are common where sellers have non-healthcare debt, whether that's over the IRS or a bank or whoever, where a buyer doesn't want the Medicare or Medicaid numbers. And that happens sometimes where competitors are, a seller is a competitor to a buyer, and the buyer just wants to absorb the seller's patient base and goodwill, and they don't need the Medicare numbers. Or where buyers are risk averse and they don't want the potential risk associated with taking on all of the liabilities they would if they did an equity purchase. I've seen both. I see both all the time. Different buyers have different risk tolerances. The other thing that can drive the decision between whether to do an asset sale or a stock sale are the kind of payer contracts the seller has. Payers generally retain the right in their contracts to approve what we call an assignment of their agreement to a buyer. If you do an asset sale and there are a lot of payer contracts under the seller, you're going to have to get the consent of those payers to assign contracts to a buyer, and that can be very complicated and it can be very risky because payers can say no, and buyers sometimes don't want that risk. In an equity sale, generally speaking, those payer agreements don't necessarily have a requirement that you go get consent for what we call a change in control, where you're not really changing the legal entity, but you are changing the owners of that legal entity. So that can often drive the choice between asset sale or an equity sale. In a stock or membership interest sale, which is an equity sale, the legal entity owning the home health or hospice agency doesn't change, only the shareholders or members do. But in that scenario, the buyer generally accepts assignment of the Medicare and Medicaid provider agreement, along with all the other company liabilities. And I will say, in equity deals, the intensity of due diligence tends to be a little bit higher. They really will go through your financials with a fine-tooth comb. They're going to be looking for any and everything that could possibly come up as liability because the buyer is going to be responsible for those. And generally speaking, what we see is the buyers will only buy the businesses if those liabilities are taken care of before you close the deal. Mergers are kind of a unique beast, and generally, I don't think I've done a merger deal in 20 years because of the size of transactions I typically do, but suffice to say that success or liability in a merger really depends on the structure of the transaction. Let's go to the next slide. So purchase price structures can vary, and they're really pretty dependent on the form of the transaction and the parties' preferences. But buyers almost universally want to pay a portion of the purchase price at closing and hold something back, usually called an escrow, to cover potential liabilities for some period of time. These are just sort of general observations on what I've seen, what Heidi's seen in our practices, but these holdbacks can usually range somewhere from 10 to 25% of the total purchase price. And that's very dependent on the risks associated with the seller's business. And the holdback periods, these escrow periods, can vary anywhere from 6 to 36 months, again, depending on the risks associated with the seller's business. You know, having done a bunch of these transactions over the last through my whole career, but the volume of transactions has really shot up since about 2019. It's becoming more and more common that we have formal escrow accounts and agreements, and I'm a big advocate of this because it really does protect the seller and ensures payment of the holdback down the road. I'm always skeptical of a deal where basically the transaction document says, I'm going to pay you, 80% of the purchase price now, and in 12 months I'll pay you the remaining portion, but they're not actually parking that money anywhere so that it's, secure and available. That's generally not a great situation for sellers. So it's important that you look at exactly how that holdback money or that escrow money is going to be handled, whether it's going to be put aside in an account ready to pay when the period of time that it's to be held expires. It's kind of critically important, and sometimes that depends on the size of the deal. Escrows aren't free. You have to pay an escrow agent to handle that for you. And so, in very small deals, we often see terms that are a little less formal, but in bigger deals, certainly we see very formal escrow arrangements. Your purchase price structure in your transactional document will also address purchase price adjustments. There are often adjustments at closing that affect the actual cash paid at closing. For example, you could build into the document that certain of the purchase funds are going to be used to pay debts of the seller or pay transaction costs of the seller. And it's very common, especially in larger transactions, that a portion of the purchase price may be used to satisfy working capital if the agency doesn't have sufficient accounts receivable sort of waiting to come in the door to provide enough working capital to run the business after closing. Let's go to the next slide. The next most important section in your transactional document will be the representations and warranties. These are actually made by both parties, but certainly sellers make far more representations and warranties than buyers do. These are disclosures, and Heidi called them promises. You can call them what you will, but what they are you're telling the buyer all of the things about your business that they need to know before they buy it. And you're representing that those things you're disclosing or that you're representing and warranting are true and to the best of your knowledge. And these can include things like that your financial statements are accurate and complete, that there's no pending litigation, there's no pending claim audits, that the business has been operated in compliance with all applicable law. There's, the list of representations and warranties in a transactional document is often the longest section of the contract. And it's very important that sellers and their counsel go through these in a lot of detail and make sure that what they're representing is true about their business is accurate. And when there are exceptions or things that need to be disclosed, so for example, let's say you're looking at the rep and warranty about litigation. Okay, well, there's a pending lawsuit against the company involving, something. It doesn't necessarily mean a buyer isn't going to buy the business, but it's very important for the seller to disclose that litigation exists to the buyer, and it's written down on what we call a disclosure schedule. And then buyer and seller talk about whether that's going to be something that changes your escrow or holdback, or how it may affect the terms of the deal overall. The other things that go on disclosure schedules can be things like you're disclosing all of your contracts that the seller entity has in place to help run the business. Those include things like payer agreements, your electronic medical record contracts, your medical director agreements, anything where you've contracted with an outside party to provide some service or something of value to the business. This is such an important aspect of representations and warranties, because many of those contracts, depending on the form of your transaction, may require consent from the other party to that contract in order for that contract to continue with the buyer after closing. That's especially true if you're doing an asset sale. Like I mentioned earlier, payer contracts often require approval of the payer for you to assign a contract from a buyer to a seller in an asset deal. Same thing with certain types of vendors. And I don't want to belabor the point, but it's really important that you go through contracts in great detail with your counsel and make sure your disclosure schedules include everything that needs to be there and hit all of the important points. Material inaccuracy in a representation or warranty can be grounds for a buyer to sue or seek indemnification. So when you fail to disclose something that you knew or should have known about, and a buyer is damaged by that, they can seek compensation. So it's really, like I said, very important your reps and warranties are thorough and accurate. Let's go to the next slide. So this is some examples of reps and warranties in a healthcare transactional document. Things like you have all your licenses and certifications necessary to operate, you're enrolled in Medicare and Medicaid and in good standing and active. The seller and their owners are not subject to disciplinary or corrective actions or appeals. Seller's done exclusion screening and doesn't work with anybody who's excluded. There's no claims enforcement or other actions, administrative proceedings, audits, or investigations pending. And especially in home health transactions, sellers often have to make a representation of warranty addressing the 36-month rule. If you're not familiar with that, it basically says that you can't have a change in direct majority ownership in a home health agency more often than every 36 months. That's really important in home health deals. It's sort of the first issue we always look at. So let's make sure we can actually sell this business before we get deeply into it. So if there have been changes in direct majority ownership within 36 months, we've got to find creative ways to work with that, work around it. So let's go to the next slide. So the next most relevant section for sellers generally and for buyers is the indemnification section of the purchase agreement. And while everybody sort of initially focuses on purchase price and getting those reps and warranties in good shape, the issue of indemnification is always high on at least an attorney's list of things we need to pay close attention to in a purchase agreement. Generally speaking, indemnification is there to protect a buyer. And in this provision, the seller agrees to compensate and hold harmless the buyer for any problems that arise in the business as a result of the seller's actions or breaches of their representations and warranties. And we often throw a number of sort of guardrails around these promises that a seller makes. For example, we'll limit how long the seller has to provide this indemnification, or will cap the amount of liability the seller may incur if a rep or warranty is breached. So these can get quite sophisticated depending on the size of the deal and the types of potential issues that a seller entity may have. This is a densely drafted provision of most documents, and it lays out not only legal responsibilities, it also generally lays out a pretty complicated procedure to make indemnification claims. So this indemnification is closely related to your escrow or holdback money, because generally speaking, that escrow or holdback is there to satisfy indemnification claims for the period of time the escrow is available. So if you're holding back 10% of the purchase price for 12 months, for example, and an indemnification claim arises during that 12-month period, the buyer is going to notify the seller, hey, we were notified by this payer that they want, $10,000 back for some services they say shouldn't have been paid to you. They're going to notify the seller of that, and assuming, there's lots of facts obviously surrounding that kind of situation, but the escrow holdback money is available to satisfy that potential indemnification claim, assuming it can't otherwise be disposed of through some kind of appeal. So that's the two kind of go hand in hand. The escrow fund sets up a pool of money that's available to pay these indemnification claims for a period of time. Let's go over to the next slide. Qualifications and exceptions can really, in a purchase agreement, can be anything that limits parties' liability. Like I said, we're going to throw some guardrails around these indemnification promises that sellers make. It can include things like a cap or on the total amount of liability a seller may have. It can include a minimum amount of damage a buyer has to suffer before they can make a claim. Sometimes we have what we call materiality qualifications, and often we have time limits on indemnifications. Those are usually not always, and it depends on, we sometimes carve these up and we'll have different time limits for different representations and warranties. Those, like I said, can get pretty complicated, and it requires a careful review by your attorney. These are always negotiable. Since they're always very, very fact specific, I can't tell you there's any kind of standard indemnification provision or standard qualifications or exceptions, other than to say it's pretty common to see a minimum amount before a buyer can make an indemnification claim. That's just to kind of keep out the non-material sort of low dollar. We don't want buyers nickel and diming sellers to death. And we almost always see some kind of time limit on indemnification. So let's go to the next slide. Closing. Closing is always well defined in the purchase document, and the favorite provision of every seller. They want to know when we're closing the deal, because that's when the money, or at least most of the money, gets paid. Sometimes closing can occur the same day the purchase agreement is signed. That is common in equity transactions, especially in Texas, because we're usually, and not always, but usually we don't have to give any advance notices to licensing if we're doing an equity sale in Texas. The exception to that would be if your agency has HHSC waiver contracts to do things like primary home care services. Those do require, in most instances, advance notice to HHSC, and you've got to plan that into your timeline. So you can't do what we call a simultaneous sign and close. Generally, not always, but generally, we sign a purchase agreement and there's a delay of some period of time, and that can range. It can be 30 days, 60 days, 90 days. It just depends on what's necessary. And we close the transaction later. This is very similar to when you buy a house. You'll sign a contract for sale and there'll be a closing 45 or 60 days later, because there's things that need to happen between the time you sign that purchase agreement and the time you actually close the transaction and the buyer pays the seller some money. Those things can include, there may be licensing notices required if you're doing an asset sale. There may be notices required, as I mentioned, to HHSC on those waiver contracts. But generally speaking, there are some what we call conditions to closing when you have what we call a delayed sign and close that have to be met before you can consummate the transaction. And in addition to licensing and regulatory notifications, this can include, in an asset deal, things like going and getting consent from various third parties to assign contracts from a buyer to a seller. So all those payers that require that kind of consent, this is the window of time between signing the agreement and closing the deal where you go and get those consents. Let's go to the next slide. All right, so at the closing, when you get there, all the parties review, make sure your documents are in their final form, everybody's happy with them. And then you officially sign the documents to transfer ownership of either the assets or the equity interest in the business. And then the purchase funds are paid from the buyer to the seller, and any escrowed funds or holdback monies are deposited in the escrow account. That's the consummation of a deal. It's always a great day for both buyers and sellers. These can be done and are almost always done virtually. It's rare that I see all the parties gather in one place to do a closing anymore. And sometimes, you know, documents can get signed via DocuSign and exchanged between attorneys, and money can be sent via wire transfer. So it's, generally speaking, not necessary for everybody to be present in one place. Keeps costs down, which is nice. Let's go to the next slide. So after closing, the relationship between the parties generally doesn't end after closing. Most buyers want some kind of transition period where the seller helps sort of ease people from the seller's operation to the buyer's operation. So there's some period of time where the seller remains available to consult with the buyer on whatever they may need assistance with. The goal of the seller in this situation is to minimize its exposure to liability from claims made by the buyer. And the buyer obviously is running the business now with all those challenges, and the buyer, it may need that seller as a resource. If issues come up that the seller should have disclosed, buyers can always seek a legal remedy after the transaction closes. So if they discover 60, 90 days after they close the transaction that there's an audit that's happening, it involves services that were provided before they bought the business, that can result in a potential indemnification claim. So buyers and sellers don't necessarily stop talking once the money changes hands at closing. And it's very, very common that there are various financial things that have to be resolved after closing. Money may continue to come in that belongs to the buyer, and so there's communication about that. So it's rare that the parties never have contact again. And obviously some transactions have deferred payments. They have these fallback or escrow accounts, and they'll rely on each other to comply with these deferred payment obligations and reporting. Let's go to the next slide. Most deals I work on have some kind of restrictive covenant. Some protect the buyer. So those are going to be things like the sellers agree not to compete with the buyer after closing. Some will protect the seller or their reputation. So covenants concerning things like the business's employees, terminations, pay, severance, things like that. These can become the subject of disputes between the parties after closing if, for example, a seller violates a non-compete. It's really important that you have your counsel read these carefully and advise you on the terms of these various restrictive covenants. The general rule of thumb is that non-competition agreements have to be limited by scope, by geography, time, and the practice area or the type of conduct that's being restricted. I'm sure someone's going to ask a question about the pending FTC rules on non-competition. My understanding is the proposed rules carve out non-competes and transactions. So we are still going to have them, and unless that rule changes in some significant way, buyers are still going to be looking for sellers to promise not to compete with the business the buyer just bought. So let's go to the next slide. Home health and hospice deals often include post-closing purchase price adjustments. These can, things like if you estimated the amount of accounts receivable that were on hand at closing and that was going to serve as working capital for the business, 60, 90, 120 days later, when that money is actually collected, it may have been too little or it may have been too much, and there needs to be some adjustment that's either paid back to the seller or that the seller pays back to the buyer. So there's often these kinds of post-closing adjustments. It's really important, especially in home health, hospice, any kind of healthcare deal, that the parties have agreed in their transactional document how accounts receivable will be split, or if they will be split, or if the buyer's going to take all the accounts receivable. This can be a really big source of contention if it's not handled properly and well. You really clearly define how things are going to be handled after closing, and that somewhat depends on the terms of your deal. It's not uncommon, especially in smaller deals, for sellers to keep all of the accounts receivable up through the day before closing, and obviously that money comes in later. You've got to set out in some specific detail, how are we going to identify those, and when will the money be paid, and how. So again, that's an important part of your transactional document, and it's also obviously something that's going to get resolved after closing. Buyers often want purchase price adjustments to discourage sellers from letting businesses fall apart during the transaction or while waiting for closing. I don't see that as big of an issue these days. Generally speaking, we're not going to have real long delays between signing and closing, but it is something that we have to be aware of. And my last comment will be, at least on this issue, will be file your Medicare and Medicaid change of info or change of ownership applications timely. This is to the buyers out there. You generally have 30 days after closing to do this. Medicare is becoming much less tolerant of people filing these late. So it's very important that your licensing and Medicare, Medicaid, all those applications get filed timely. Let's go to the next slide. So some specific issues for home health and hospice. Licensing requirements often drive your transaction timeline. I'll give you an example. In Texas, if you're doing an asset sale, the buyer has to file a license application if the legal owner of the business will change. So new owner, new tax ID number. Generally speaking, a minimum of 30 days in advance of the sale. Absolutely do not complete an asset sale before you deliver this license application to Texas HHSC. They can pull the license if you do that. That would be disastrous for everybody. In equity transactions where you're doing, a buyer's buying the shares or equity interest in an LLC, generally speaking, as I said before, these don't require advance notice to licensing, and you can generally have a shorter period either between sign and close, or even in some cases do a simultaneous sign and close. Asset or equity deals, it doesn't matter. If your seller agency has primary home care contracts with HHSC, they require 60 days advance filing of a full new application if there is a large enough change in majority ownership of the agency. It's really important that if your seller agency has these contracts, this is built into the transaction, because HHSC is very, very strict about their rules about how these are handled. Often we see buyers want to manage a business during an interim period between signing a transaction document and closing a transaction, especially when we have home health agency 36-month rule issues. So if you had a home health agency that had a change in majority ownership 12 months ago, but you got a buyer who wants to buy the business, I have seen deals where we sign a purchase agreement and the buyer basically takes over management and is financially responsible for the business until that 36-month window expires. It's not uncommon now. The longer that period of management is, I think the more risky it is for sellers. And it can get messy. I'll just leave it at that. But in those situations, it's really important you have a robust management agreement between the buyer and seller during that interim period. That's generally built into the purchase agreement. It becomes an attachment to the purchase agreement. And it defines what the buyer's responsibilities are during that management period, how the financial relationship works, and who's going to bear liability for certain things. So something to keep in mind. Let's go to the next slide. So always be vigilant about payer contract assignment provisions, because if you don't go get those consents timely, it can result in your contracts being terminated. It's important to consider for buyers what staff will you retain, because often that's key to retaining patients. Don't forget about your accrediting body. Generally, they need to be notified of any kind of change in either shareholders, or if it's an asset deal in the actual agent entity that's going to own the business after transaction occurs, and they've got paperwork they want you to fill out. Accreditation generally does transfer in all these kinds of deals, but you do need to keep them in the loop. Buyers should be reviewing sellers' compliance plan, policies, and procedures in any internal audits and external audits as part of their due diligence. Consider cost-saving strategies that could be realized in a transaction, such as removing redundancies, streamlining technical and administrative systems, and increased outreach and marketing efforts. These are the sort of motivations, generally speaking, for buyers to seek out a particular seller. Let's go out to the next slide. All right, so in conclusion, transactions are complicated. Often they take months to get to closing. But I will say sellers generally that I work with, and I do a lot of representation of sellers, we get them to the finish line 9 times out of 10. Whether you're buying or selling, always make sure the target business continues to operate in its customary manner while negotiations are pending. Be cognizant of fraud and abuse issues, including Stark and anti-kickback. Hire experienced professionals to help you handle the transaction, valuation and negotiation, and this can include attorneys, appraisers, and accountants who can give you good advice. And be aware of the long-term risk allocation issues that may go on long after closing. Sellers giving buyers that indemnification for things that might come up after you sell the business. Last slide, that's contact information for Heidi and I. And feel free to reach out to either of us if you have any questions. We appreciate you guys listening today. And Gio, do we have any questions?
Yes, we do actually. Give me 1 second and let me pull these up. All right. So one of the questions is, in asset or equity sale, can a buyer take over the money in the bank?
That's entirely up to the parties.
Yeah, I've seen it work all both ways. Yeah, sometimes the seller retains it, sometimes the buyer takes it over.
Correct. It's just part of the negotiation of the purchase price.
Mm-hmm.
Okay. The next question is offering a family member or an employee a certain percentage of your agency considered a sale? No charge of name or EIN.
Anytime you put some portion of the equity ownership of your business into someone else's name, you can, let me put it this way, you could set the terms of that, but it can trigger, it needs to be documented first and foremost, and it can trigger reporting obligations on things like your license, your Medicare and Medicaid enrollment, so that they understand that there's a new owner, especially if that person's going to own 5% or more of the business. My recommendation is, if you want to do that, you need to consult with counsel so that it's properly documented, that you have the right resolutions in place, and that it's done in compliance with the various fraud and abuse laws as well. Heidi, anything more to add there?
No, I would agree. The other thing is, again, you need to do some due diligence. I mean, presumably as an employer, you know pretty much about this person, but to some extent you do need to do some due diligence on the person as well. You don't want to have something like your employee inadvertently be excluded, which I've actually seen happen where the employer didn't realize the employee was excluded. So just, think through it, and as Jennifer said, retain counsel and be thoughtful and cautious how you do it.
Okay. Yeah, that's the only questions we have for today. So that concludes today's webinar. Thank you for joining us, and thank you to our speakers, Jennifer Papapanagiotou and Heidi Kocher. Everyone from today's webinar will receive a copy of the presentation slides via email. Just check for on your junk mail or your regular mail. If you have any further questions about today's discussions or another healthcare law issue, please feel free to reach out to them or Laos Parker. Other than that, have a good Wednesday and take care.
Thank you all. Bye-bye.